The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 958, coming to you on Monday the 30th of December 2019, the last Monday for the year 2019. On this program, I will speak to you on the topic Administration of Estates of Intestates. And just before getting into the program, a few preliminary remarks. Firstly, condolences go out to all families which have suffered recent bereavements. And secondly, and most importantly, I would like to wish a Happy New Year to one and all. I must single out for special greetings the management and staff, particularly my videographer staff, of SVG-TV for having carried the Law and You for these many years without charge. And I'm so appreciative of the service rendered free of charge by the management of SVG-TV. I should say the St. Vincent and the Grenadines Broadcasting Corporation. But apart from that, Happy New Year to everybody within the sound of my voice and the viewing of this image. I hope that 2020 will be productive, enjoyable, prosperous, and that it will see the fulfillment of our hopes and dreams. Do have an enjoyable New Year holiday, and let us look forward to greeting the year 2020, and let us look forward to what 2020 has to offer. And remember that in your festivities, do so with moderation. Let us try to avoid accidents and other calamitous situations. And let us hope that the new year will meet us in good health. Okay, the topic for the evening, Administration of Estates of Intestate. To those who would have been viewing the Law and You for these past years, I would hardly think I need to explain what is meant by those words, but I operate under the assumption that there are always new people or people who are looking at the program for the first time. And therefore, when I use certain expressions, even though I have used them time and time again, I have a tendency to want to explain them for the benefit of new viewers. So to those who understand these things quite clearly, don't be bored. Nothing is wrong in hearing it again. Administration. The word refers to the process by which the estate of a deceased person is administered. And you might object that that definition is somewhat circuitous, and it is. You see, the dead cannot do anything for themselves. Once you're dead, that's it. Secondly, those who die usually die and leave behind them items of property. Real property, which means land and buildings, and the personal property, anything that is not land or buildings. Personal property like vehicles. You may die and leave a boat, a seine, some animals, jewelry, the proceeds of insurance policies, monies in a bank, monies due to you from sundry sources, a pen, cufflinks, earrings. They are all items of personal property, and together they make up what is called the estate of the deceased person. Now, when we grow up and we hear about estates, the first thing we used to think about is a massive parcel of land. Land settlement estates. We had where I grew up, the Barley Estate, the Curtains Estate, the Wallabo Estate, Torma Estate in the countryside, the Orange Hill Estate, the Argyle Estate. Those refer to large acreages of land. But the word estates has a wider signification, meaning anything at all that is capable of being left behind by a deceased person. Whether the deceased person had it in his or her possession, or whether it was expected. For example, if somebody dies and they are owed money by somebody else, you can't say the deceased died with that money in hand, but the deceased would have died being entitled to the monies which were owing to him or her. Anything, therefore, owing to a deceased person at the date of his or her death would form part of the estate of that person. So when you hear in law the term estate being used, it simply means all the worldly possessions of somebody who has died. And therefore, since the person is dead, somebody who is alive has to take charge of matters and organize the estate of the deceased in the way that the law prescribes. That process is called administering the estate of the deceased. Now, the last part of the title of persons of intestate, well, you would know that when a person has died leaving a will, we say that the person has died testate. When a person dies without having left a will behind, then we say the person has died intestate. Now, testate succession is governed by different rules, because testate means that the person left a will. Therefore, the administration of that person's estate amounts to getting authority from the court, getting the will certified that yes, this was a true, valid, authentic will, and somebody being left in charge of fixing up things on behalf of the deceased person. In the will, therefore, somebody would have been named as the executor, and if a woman, executrix, so that every will would say, I appoint so-and-so to be the executor or executrix of this my will. That means you are leaving somebody who will be in charge of your affairs. Now, since we don't know who will die before whom, you might ask the question, well, suppose a person makes a will, names another person as the executor, and the executor dies before the person who made the will. Well, in that case, rules provide who should take over. That is, either the person who made the will could make a fresh will, or could make what is called a codicil, that is an amendment to the will, naming somebody new as executor. But there are rules to determine that. But on this program, we are dealing with people who die without having made a will, which happens to be the vast majority of people who die. The vast majority of persons who die, certainly in this country, die without having made a will. And just in case you're wondering, a will is a document, it's a piece of paper on which is set out what the deceased person wants to happen to his or her estate. So the will may say, I am giving parcel of land to my son, I'm giving vehicles to my daughter, I'm giving my sailboat to my cousin, and so on and so on. So the will sets out what you're leaving for whom. Just reminds me of the saying, where there is, there's a saying, where there is a will, there is a way. There's another saying, where there is a will, there are anxious relatives waiting to see whose name is in it. Anyway, that's just by the moment of levity. All right, so on this program, I am going to remind because these are things I have spoken about time and again. But I'm going to remind you of some of the legal rules which allow the courts to determine who should get what out of the estate of a person who has died without having made a will. So the law says, if a person dies and the person has not made a will, in order for you to determine what happens to that person's estate, you have to look to see if the person died leaving a spouse, if the person died leaving children, because the law is very specific in this country and in many countries as to what should happen to the estate of a deceased person who dies without having made a will. So in St. Vincent and the Grenadines, if somebody dies and they left worldly possessions, you look to see if they had a spouse, if they were married. And married means legally, lawfully married, not dewed for 50 years. We call those common law marriages, but that term is a misnomer in that the law doesn't recognize the persons who haven't gone through a proper lawful marriage ceremony as having been married. Remember that, and no matter how long a man and a woman have lived together, if they haven't gone through a ceremony of marriage recognized by the law does not regard them as having been married. It doesn't matter how long they lived together. It doesn't matter how many children they had together. If they didn't go in church or in some other place they recognized by the law and take appropriate vows and sign appropriate documents, the law does not regard them as having been married. So we're talking about people who are lawfully married. So if somebody dies, we look to see if they were married at the date of their death. And if we discover that, yes, they were married, we then look to see, did they have children? No, it doesn't mean children of that marriage, assuming they were married. Because a person could have been married to somebody, had children before the marriage or even during the marriage with other persons other than the spouse, but none of those children belong to the lawful spouse, that is the lawful wife or husband. So the law says, if the person who dies without having made a will was married and had no children, the surviving spouse, that is, suppose the husband died, the wife would be the surviving spouse. If the wife dies, the husband is the surviving spouse. So the law says, if the intestate, that is the person who died without having made a will, dies leaving a spouse and no children, then the spouse would get, what's your guess? All of what they had? No. The spouse would get 1/2 of the estate of the deceased spouse. You may ask, what happens to the other half? Well, coming to that. But if the intestate dies, leaving a spouse and children, follow me, the spouse who is alive gets 1/3 of the estate of that intestate, and the remaining 2/3 of the estate would go to the children of the deceased, whether they belong to the surviving spouse or not. Naturally, those children will have been born out of wedlock, unless the person was married before, had lawful children or children in lawful wedlock with a wife and a husband, and that spouse died, and the person got married a second time, then you would have the children of the first marriage. But once they are regarded in law as children of the deceased, they are entitled to 2/3 of the estate of a person who has died intestate, leaving his spouse and children. Suppose the intestate leaves no spouse, then the children of the intestate would be entitled to share up the estate left behind by their deceased father or mother, as the case may be. Suppose the deceased had no spouse and no children. Then the law says in that case, the parents of the deceased, if alive, would share the estate of the deceased. And if only one parent was alive when the intestate died, that parent will get the entire estate of the deceased person. Okay, suppose there was no spouse, no children, no parent. Then the law says, in that case, the brothers and the sisters of the deceased, well, brothers and sisters of the whole blood of the deceased, that is, full brothers and sisters. If no full brothers and sisters, then half brothers and half sisters would inherit. So the law has categories of succession. Therefore, and so on. I did not exhaust all the possibilities. You have cases where down to uncles and aunts could benefit. But the whole point is, if somebody dies without having made a will, you look at the Administration of Estates Act, and that sets out how the estate of the deceased should be divided between those who are alive. That brings me to a problem which many lawyers have encountered. Well, there are several problems because people they go crazy over dead left. People get into all sorts of difficulties, all sorts of tangles, quarrels, fighting over what somebody has died and left. And the usual case is that somebody who is not entitled at all according to the law wants to step in and claim something from the estate of the deceased in circumstances where that person who is making that claim is making a false claim. According to the law, he or she is not entitled to anything, but he or she wants to step in and claim. One usual case is where children are born out of wedlock and only their mother's name is on their birth certificate. Now, in the eyes of the law, if your mother's name alone is on your birth certificate, that is the only parent the law recognizes. You could always say, well, everybody knew so-and-so was my father, but is his name on your birth certificate? And if the answer is no, well, crap or smoke your pipe. So I have been saying for the longest while, those of us who have parents Well, fathers whose names are not on our birth paper should hurry up and make sure our fathers' names are on our birth certificate, if we are to stand a chance of inheriting anything he left if our father dies without making a will. Now, if our father has made a will and puts our name in the will as being entitled to this or that, well, then we get what our father said we should get. But I'm speaking about the cases where our father has not made a will. Then you can only get something from that will if your name is on if his name is on your birth paper. Then you have quarrels by grandchildren. Now, in the eyes of the law, when persons die without having made a will, their children are entitled to share up. Not their grandchildren. Grandchildren have no pose unless the parents of those grandchildren have died, and the grandchildren step into the shoes of their dead parents. But where the grandchildren's parents are still alive, the grandchildren have no pose, no authority, no entitlement at all, because grandchildren can only claim through their parents if their parents have deceased. But once your parents are alive, you can't say you're looking for something that grandpa died and left, because what he died and left is to be shared up between his children, not their children. Okay? All right, now I would wish to continue with this topic next week, Monday, DV, because there are many more things I want to explain to see if persons could be made to understand that if you get a grant of letters of administration from the court, it doesn't mean you are entitled to take the estate for yourself. And hopefully next week in the program that I will do, I will explain what are the responsibilities of somebody to whom the court has given a grant of letters of administration. Too many times somebody dies, somebody rushes to administrate, gets a grant from the courthouse, and feel that the property belongs to them, they can do as they want with it. No way. All right, so that is all from this program of the Law and You, program number 958, coming to you on the last Monday in December 2019. I look forward to being of further service to you in the year 2020, if it be the will of the Lord. Until that time, may the good Lord continue to bless us all. Happy New Year to everybody.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.